Hi, everyone. Let's see if I can figure out this newfangled system that they have here with Facebook Live because, we had to go make it better for some reason, but really more complicated for those of us who are not technologically advanced. But we're making it work. So I'm just going to give it a little bit for people to start coming in. And we're going to do part 3 of our expert witness conversations that we've been having. So yeah, this should be good. This should be fun. We're going to cover the last part, which is cross-examination, of course. And we've already talked about Daubert and how it works, why it works, what it is, where it comes from out of 702. Last week, we talked about voir direing the expert witness and what that means, the fact that it's really just about the qualifications of the expert. That's what you're talking about. And that's what you're addressing during that time. And this week, we're going to talk about cross. We're going to talk about how to effectively cross-examine an expert witness. And I got 3 steps for you, 3 little steps, because these are our 10-minute talks. Trying to make them efficient, but full of information. So let's go ahead and get started. All right. So the 3 steps that we're going to go through when it comes to expert testimony and what it is that we want to do. Our first step is actually prior to trial. It's during the deposition. You want to box them in. So what do I mean by that? When you get ready to do your deposition of your expert, you want to nail down what it is this expert is going to testify to. The federal rules require them to give you a report that the expert has drafted, if they have drafted one, for any testifying experts. Now we know, well, we don't know, but we will know that there is a difference between testifying and non-testifying experts. But for testifying experts, they have to disclose the report. Rule 26 requires that. So you get this report. You go through it with a fine-tooth comb. You try to figure out exactly what it is that this expert is opining about, what their opinions are, and how it may affect your client. Once you do that, you start prepping your depo. And in prepping your depo, you're going to want to ask particular questions and figure out particular things. They have to be open-ended questions, of course, only because you get more information that way, and it's required that you do it that way. But you also want to think about what the objective of this depo is. The objective is to nail down this expert. Remember, experts are smart. Some of them too smart. And because they're that smart, one of 2 things happen. They either talk to you as if you are beneath them because they're so much better than you and they know so much more than you could ever know, ever. Or they get lost in the weeds, meaning they explain everything in a technical manner and you have to work to get it into layman's terms, which is what you'll have to do before a jury panel anyways. So when you're working up your depo prep, what you want to do is think about a couple things. So one of the first things you want to ask them about is what are their exact opinions in this case? More specifically, what are their exact opinions about your client's liability in this case? So I had a case once where it was an expert on damages. So it's an accounting expert. And they're talking extensively about the damages regarding my co-defendant. And they're going through it, hours into this depo. We have only talked about what they think the damage liability is for my co-defendant. So I had to leave early, and early was 6 p.m., as if we didn't start this depo at 9 a.m., okay? And I asked to be able to ask my questions. When we got through, I had one question. Do you have an opinion as to the damage liability for my client? Expert answer, no, I don't. I'm done. I have nothing else to say to this expert because that's all I needed to know. All I needed to know is, do you have an opinion that affects my client? So when you're doing these depositions, that's one of the things you want to ask. One of the ways to ask it is, what is the exact opinion you intend to give at trial? because this way you can now nail them down to specific opinions and specific testimony. You also want to ask, what are the basis for these opinions? So what are you basing your opinion on? Is it based on mathematical theory, accounting principles, physics? What is your opinion based on? The third thing you want to make sure you ask them during the depo is, are there any assumptions underlying those opinions? Meaning, are they assuming that water is wet? Are they assuming that the sky is blue? What assumptions are they using in order to come to this opinion? The reason you want to ask that is because you want to figure out if there are any faulty assumptions that they're using. So when you start with step 1, which is the deposition and the depo prep, you are digging into and drilling down into why this expert has the opinion that they have, what the basis is for that opinion, what that opinion is, and how it works. You usually, or some people will end, and I do this, where you end the expert depo with, are there any opinions that we have not discussed today that you intend to give at trial? The reason you ask that question is because if the answer is no, you have done 2 things. First, you have boxed them in efficiently so that there cannot be a new opinion raised at trial. If you don't ask that question, what any wise expert will do is say, well, you never asked me. I've always had this opinion. They probably didn't, but then they probably developed that opinion after they talked to opposing counsel after the depo, and they were like, hey, we never talked about this. Or they might not, they might have always had that opinion, and for whatever reason, you just never addressed it. If it's not in their expert report and it doesn't come out during that depo, technically they should not be testifying to it. And those would be valid grounds for you to ask for the testimony to be stricken or for the testimony not to happen at all if you find out about it ahead of time before they get on the witness stand. The other reason you want to ask that is because if for some reason you get a judge that does not limit the testimony, now you've got good impeachment. Because when they get up there and they talk about the fact that, they have an opinion that the sky is purple. Well, expert so-and-so, do you remember having this depo? You're going to do your impeachment steps. Commit, credit, confront. You're going to commit them to this testimony that they now have this random opinion regarding your client. And you ask them specifically, are there any other opinions that you wish to talk about? And their answer was no. So now they've got this new opinion that comes out of nowhere, and you can drill into that during your closing and show bias on the part of the expert. So step 1 is good depo prep. That is really where your cross of an expert begins. The other thing you want to do in your depo prep is find out what treatises they rely on, which ones they think are valid, because that is also a method for impeachment, which we're going to talk about in about 2 seconds. So you want to figure out what treatises they rely on, whether or not they've heard of any of the treatises you know about or you intend to rely on or your expert intends to rely on. Because you have to set it up in order to be able to use 803.18 the way it's written. So what do I mean by that? Well, step 2 is develop a theory for cross. You should have a theme and theory for your case. You should. And if you have no idea what theme and theory is, scroll back through videos that I've already done, because I've done one on theme and theory that I've posted on the page. But you should have an overall theme and theory for your case, meaning what is your legal theory? Why do you win? And your theme, how am I presenting it to the jury? But you should also have a theory of cross, meaning what do I need from this witness? Do I need this witness to help me? Or do I need to hurt this witness? Those are the 2 considerations on cross. So when you develop your theory on cross for your expert witness, you're going to want to think about, how do I want the jury to view this witness? How do I want them to think about this expert? Do I want them to think that the expert is honest but mistaken? Because that's possible. Do I want them to think that the expert has faulty assumptions, that their science just isn't as solid as they're presenting it? Do I want the jury to think that the expert has faulty factual conclusions, meaning the expert is going on factual assumptions that actually are incorrect? Or do I want them to think that this expert is wholly biased? Wholly biased, it's not that it doesn't happen, but it's a little, it's not rare either. That's not the right phrase. But usually, financial bias, that comes at the bottom of the list only because every expert gets paid to testify. So, harping on the fact that the expert is getting paid to testify really isn't getting you anywhere. But if they only testify for one side, they only testify for the defense, or they only testify for the plaintiff, that's a bias that you can use. If they only testify in particular cases, meaning they only do wrongful death cases because the damages are high and they can charge higher fees, that's how I can use financial bias a little differently than so you're getting paid to be here. Another thing you want to think about is the difference between a treating expert and a non-treating expert, meaning, does it matter? Does it matter that this expert has never talked to the plaintiff, has never investigated the actual injuries, has never had any conversation with the client? Does that matter? If it does, that's something else that you can use in your theory of cross. Remember, I'm trying to figure out help, then hurt. How do I use this witness to further the story that I'm presenting to the jury? Another way you can think about your theory of cross is, do the experts agree? Are there key parts where your expert and opposing expert actually agree? Because then you can play that up in front of the jury instead of digging into the things that you know are going to hurt you. It's like, okay, fine. We disagree whether or not the sky is purple, but we do believe that the sky is up and not down. We do believe that there are clouds in the sky. We do believe that rain comes from the sky. You can play up all the things that the experts agree on to show why this is not something that, sorry about that. That's what happens when you're live. My alarm starts to go off. But you want to show that this is not something that really the parties are at odds, that they actually agree on the majority of things, if they do. So you want to develop this theory. So step 1, depo prep and depo questioning. Step 2, develop your theory for cross. How do you want the jury to view this expert? Step 3 is do it, meaning conduct the cross. The key thing to cross for every single witness, and especially an expert witness, is a short, one fact question. You want to box them in with your questions as best as you can. A good expert knows how to use your cross-examination question to eat you alive. They know how to use the question to further expound on what it is they want to talk about. So you have to be deliberate in asking short, one fact questions. You do not put too many words into the question if you do not have to. And also think about your audience. Your audience is a jury panel who has probably started to fall asleep during the expert testimony. You don't want them to do that during cross, okay? Because they're already nodding and nodding and nodding, trying to figure out why they care about E equals MC squared. You want to get in and get out. Expert cross-examination should not take days. It just shouldn't unless absolutely necessary. It should be a real short, brief, get in, get what you need, and get out type situation. You want to be strategic about what you ask this expert. You want to be strategic about how many issues you address with this expert. Really, 3 or 4 main issues that go towards your closing that you absolutely need from this person is really what you want to try to get. So think about your depo. Think about boxing them in, because that's the purpose of the depo, nailing down the exact opinions that they have, how they work, why they work, and what they're based on. Then think about how you want the jury to view this expert. How do you want to present them? What is your theory for cross of this witness? Then do it. Be strategic about it. Be cunning about it, meaning know what you need and know what you don't. And then go get it. Go get it with short, one fact questions and get that witness off the stand. When you do a short cross, you limit redirect. Remember that. You don't want this redirect from opposing counsel to go on forever and now be a rehash of direct. So if you limit the scope of your cross, you can limit the scope of this redirect and be able to manage the extent that this expert witness testimony can hurt your case in any way. There are some where it just sucks. It absolutely sucks. That is a technical term. It sucks. Okay. This witness, for whatever reason, is shredding your case to pieces. You're just going to have to fix that with your expert. And you're also going to have to know when to shut up, meaning don't get up and try to do a cross to fix the fact that this witness sucks. Get up and do the cross that you need and sit down. Sometimes, and I know there are some people and there are a lot of people who are going to disagree with this, you can actually not cross an expert witness. There's nothing that says you have to cross an expert witness, but you cross the expert based on your theory of the case. That's what you need to do. Okay. And if for whatever reason, this expert doesn't say anything that harms you, okay. That same case, we ended up settling it, but had it gone to trial, I would have asked the expert the same exact question on cross. You do not have any opinion regarding my client's liability in this matter, do you? No. No further questions, Judge. One question is all I would have had on cross. So just because they're an expert doesn't mean you need to talk to them as long as opposing counsel did. You need to get what you need, not what they need. And that's cross-examinations of experts. If you guys have any questions, feel free to reach out. I am always happy to help however I can. And please stay safe and try to stay as positive as you possibly can. I know that's hard during this time, but it can be done. You know, we still have things to be grateful for. But feel free to reach out with any trial questions that you have, and I will see you again next Wednesday. Have a good one. Thank you.